Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukara. Professional Ethics class. Jurisprudence. Let us complete jurisprudence first. So, refer to question paper 2017 and question number 17 also. The protection of minors and child is an important obligation on the part of the state. Yes, we have to agree. Protection of the minors and child, it is an important obligation on the part of the state. So, for this purpose, the state passed certain enactments. Some of the provisions infringed the fundamental rights of the people. So, people feel that their rights have been infringed. So, justify the validity of these enactments. So, I think by now you might have understood the problem. So, definitely the state can make acts, rules, regulations for the welfare of the minors and the children. It is an important obligation of the state. You know that law creates rights, obligations as well as duties also. So, of course, some of the provisions might have, I don't say might have, some of the provisions people feel that they are infringing the fundamental rights, like right to practice any profession, trade, like that. So, if that is the case, what to do? Justify the validity of these enactments. Happily has given the question in a positive way. You have to justify, yes, we have to justify as students, we will have to write in a positive way. Now, the issue is whether the state can pass certain enactments for the welfare of the minors and children, infringing the fundamental rights. Right? So, already in previous case also we discussed there should be rationality. No doubt, the fundamental rights, they are not absolute rights. If you know this, yes, it is sufficient. They are not absolute rights. Article 19(2) says they are also subjected to reasonable restrictions. Even reservation, it is a protective discrimination, is it not? So, coming to the point of jurisprudence, this is related to social justice. Social justice, minors, children, other downgraded persons. Child is considered as the national asset, and child is the future of the nation. And the exploitations of the children are, number one, sexual exploitation, then child marriage, third, child prostitution and child labor. These are the exploitations in the fields where the child is subjected to. United Nations Conference or Convention of the Rights of the Child, 1989, describes child as a person, as a human being below 18 years of age. Even our constitution has given so many regulations. Article 21A, that is free and compulsory, free and compulsory education to the children below from 6-14 years. Article 24, no child below 14 years shall be employed in any factory or hazardous process. And Article 39E, children should not be forced by economic necessity to the avocations unsuited for their age or strength. So, a person, a boy aged about 10 years, he should not be engaged in a tannery or in a matchmaking factory like that. So, Article 25, that is the EPSP says early childhood care and education. So, these are all the regulations made in the Constitution, not in the Acts. Of course, Acts are there, Child Labour Prohibition Act, then Guardianship and Ward, Minority and Guardianship Act, so many acts are there. Even Juvenile Justice Act, all these things are there. And for this purpose, different acts have been enunciated. I want to tell the names of which. The Employment of Children Act, 1938, Factories Act, 1948, the Child Labour Prohibition and Regulation, 1986, Juvenile Justice Care and Protection, 2000, Right to Education Act, 2009. And as regards minors, Guardian and Wards Act, 1890, Hindu Minority and Guardianship Act, 1956, and Hindu Succession Act, 1925. So, even in the IPC also, Section 317 IPC, it deals with selling a minor girl for prostitution is made an offence under Section 377 IPC also. And bonded labor, you know, any person cannot be confined or detained. So these are all the regulations. No doubt, here the point is it may infringe the rights. For example, if an adolescent boy is not allowed to act in films, for example in a TV show, then is it not infringement of his fundamental right to practice any trade, any profession he can act? So that is an objection. Similarly, if a boy wants to work in a tea shop of his parents, if it is objected to by the so-called Child Labor Prevention Act, yes, definitely it is infringing his fundamental right of the so-called trade or business. Like that, there may be infringements, but they are all subjected to the reasonable restrictions. So definitely, we have to justify the validity of these acts. For that, I want to tell you the following case laws. Very good case law. Bandhua Mukti Morcha versus Union of India 1984. So this is regarding the child labor. So actually, Bandhua Mukti Morcha highlighted the plight of the children in the so-called carpet industry. They are taken as a bonded labor. So please remember, in this case, Honorable Supreme Court of India held that the court must proceed that the labor is a bonded labor, particularly in this carpet industry. The state should owe its obligation to identify, release and rehabilitate the labor, because child exploitation in carpet industry is more. Here, particularly the minor children below 14 years of age, they have discussed in this case. Second case is J.P. Unikrishnan and others versus State of Andhra Pradesh, 1993. So this is regarding a right to education. Supreme Court held that citizens have got fundamental right and every child has the right to free education, free and compulsory education up to 14 years, what is stated by Article 21A of the Constitution of India, or Right to Education Act 2009. Right? And as regards minors, these two cases will be important. Uttam Chand versus Mohan Das, 1964. Uttam Chand versus Mohan Das. So, minor filed a suit for vacation. Of course, his guardian signed on behalf of the so-called minor. This is a contract. Whether the contract is valid or not, please remember, minor cannot be made a partner. Of course, he can be made a partner through his guardian. Here, the guardian cheated him. Without his knowledge, he has taken the signatures. So ultimately, after becoming a major, definitely it stated that this contract will be void, 100% allowed. Likewise, Lingo Bhimdo Naik versus Dattatreya Sripada Jamadagni. Oh, Dattatreya Sripada Jamadagni, 1937. So, undue influence, the guardian used influence and obtained the consent of the so-called minor. So after attaining majority, yes, he reputed the claim as allowed. So minors are normally they given preference. That's why no contract should be allowed by the minor. Of course, he can do it with the consent of the guardian or next friend. Likewise, as well as Hindu Minority and Guardianship Act is concerned, very famous case law, Geeta Hariharan case, where previously father was the natural guardian. But with the courage shown by Indira Jaising, yes, mother is also made as natural guardian under certain special circumstances, particularly the girls. So all these are welfare measure, social welfare measure, social justice measure. In jurisprudence, law should do the so-called social justice. We studied it. So therefore, please remember, if you remember these case laws and cite them, and for what? For justification. Therefore, you have to write the conclusion like this. The Child Labor Act 1986 should be amended so that more focus should be given to rehabilitation than regulation. This is a recommendation, just like since they asked you to justify. Second, the judiciary should also be more sensitive in dealing with the child labor cases. Wherever it is possible, benefit of doubt should be given to the accused persons. So, please remember, definitely the state can make acts or regulations So for the benefit of the children and minors also. Yes, with this I am concluding. Thank you very much.